Yeah, I'm about to start.
Were you able to get into the operation?
I did, yeah.
This, did you go to settings and
Settings and did that, yeah. I got everything, I think.
settings and it says re-enter password?
Yeah.
And mine is go wrong.
Oh. Because it says, then you get taken to a place where you're putting.
Yeah, it says just,
Oh, got it.
I should just reboot it.
Yeah.
Yeah, I got 3 bars from there.
Yeah, I've got one too.
Got the same one everywhere, I would say.
But I didn't get that spin wheel.
Okay.
Brian, do we have enough people? Should we get started if the professor's ready?
We have enough people.
There's Sochi, here comes Anna,
Yeah, we're still waiting on Jane,
Jane.
which, these presentations are stored online as video and as a PDF file of the slide deck. So, there's no critical, oh, there's Jane. Never mind. Yeah.
I think we're
So
ready.
I think we could start. Professor Green is with us again. And I noted in the memo that this is the last presentation that Professor Green will be making for the commission. And so I wanted to be sure at the outset to express my sincere thanks for the work that he's done. It's been an enormous help, I think, to the commission. And when I approached him and asked him about it, he didn't even hesitate. He's had to check with his employer to make sure there wasn't a conflict problem. But in terms of his willingness to dedicate the time that he has to helping the commission on this project, he was immediately receptive to that. And I really appreciate that and respect the contribution he's made to the state of California. So my thanks to Professor Green before he starts.
Well, many thanks. I wish this commission the best luck in carrying out this extraordinary mission that you've been assigned. I mean, it is really a remarkable opportunity to start from scratch and think through what a 21st century antitrust law might look like. So it's been my great pleasure to have this opportunity. And before I get going with my slide deck, let me mention I do have a bandage on my face. I had relatively minor Mohs surgery to take a little precancerous spot off my upper lip. So the spot is small, the bandage is much bigger. So hopefully that won't prove to be a distraction as we're going through this. So should we go ahead and get started, Brian?
Yes.
Okay, next slide.
Oh, wait a minute. There we go.
So the usual disclaimer, I am not representing the views of my employer, the Antitrust Division of the U.S. Department of Justice, nor the University of California College of Law in San Francisco, formerly UC Hastings. The agenda today is really, go to the next one. The agenda today is really to sort of focus on internet platforms, so hearing of Google and Facebook and Amazon, et cetera. So the start of this agenda really focuses on the attributes of these things. So as you know from our prior conversations, antitrust law at the federal level really started in 1890 with the Sherman Act. That was the era of United States Steel, mergers of various kinds, John D. Rockefeller, below cost sales and various things. This world is a very different one. And the economy, the economics of platforms are different from the economics of other kinds of products and services that antitrust law has dealt with in the past, with the exception of cases in the late 20th century like Microsoft. So I want to go through some of those attributes and then try and surface some of the implications of those attributes. I then want to turn to some cases. This is a select list. Mostly I want to use this as an opportunity to share with you some of the perspectives, some of the some of the lines of battle that are taking place in the cases. Also, several of these cases, including a case I'm working on, which is United States versus Google, are going to trial very soon, as is true for some other important cases. So what the capability of current federal antitrust law may be in this space, it will be illuminated in a far more clear way, probably within the next 12 to 18 months. So I'll talk about those cases. And then the final bit here is about 8 slides, talking about this opportunity you have to start with a blank piece of paper and write a 21st century antitrust law, and the kinds of questions and options you may have at a very high level for you to think about. Throughout this, both at the end of the attribute section and the policy questions section, I've got a handful of resources that I think might be particularly useful for you. Touchstones or just reference pieces that you can go back to. So let's start with the next slide. Next. So the first and perhaps most important thing is some sense of what are called network effects. So these come in 2 flavors or buckets. The first are direct network effects. So think about a telephone system. So if I purchase telephone services and by buying that, I get access to Brian's phone, Commissioner King's phone, my son's phones. Every addition makes that network more valuable to me. That's also true, say, for a social network like Facebook. So if my kids are on it, plus my friends, the more of my friends are on, the more valuable this becomes. So that's what's referred to as a direct network effect. An indirect network effect, probably the best place to start is this example that I suggested. So the more people, this is drawn from the Microsoft case, the more people who employ a specific operating system, think Microsoft, the more likely application developers are to build their apps on top of that operating system. That in turn makes that operating system more valuable and useful because more apps are written to it. So if you're in the Valley and you are talking about these kinds of things, sometimes this is referred to as a virtuous cycle. Growth begets growth and then spins up. So sometimes I'll talk about spinning, getting the wheel spinning, but what they're talking about are network effects. Next slide. So the other aspect of these platforms is something called scale effects. So here, for example, think search, Google, Bing, DuckDuckGo, all of those kinds of companies. So the more searches are done on your search engine, the more information you have about the things people are searching for, which means the next time somebody does that search, you can respond more quickly and accurately. So this increases the value of your search engine to searchers, because there have been a number of other people who have done similar or the same search. It also increases the number of searchers because you have a better search engine, which in turn increases your ability to provide better and better search results. Advertisers in this world also get better results because they know more about you based on your prior searches, so they can rifle shot their ads to you based on what your previous searches have been and what others have done. So these search scale economies favor larger companies. So one of the implications of the combination of network effects and scale effects is that there is a tendency to result in larger, more dominant firms. Next slide. So one of the other aspects of these platforms, so when you took economics like Econ 1, there are a certain set of assumptions about what a rational economic actor will do. And that's built into the part of the world that we use mostly as antitrust laws, which are antitrust lawyers, which is microeconomics. There's a separate study of not what people are supposed to do based on the assumptions behind classic microeconomics, but what they actually do. And this is referred to as behavioral economics. And that bit of learning, that focus, becomes particularly important with scale, with platforms and platform businesses. So for example, preset defaults on a phone or computer strongly bias people to use that particular software. I mean, it may be the case that you can take 2, 5, 10 steps and switch away, but if it's kind of working okay for you, you're going to stay. And default contracts turn out to be a very big deal in this search space. So there is the case that both courts and companies need to think about what consumers actually do as opposed to what classic economics say they will do. And this is an area that is something litigators in this space are having to deal with. We've got experts that talk about this and explain why it's important. And if you know, business documents and people that analyze how these businesses work, talk about defaults creating friction so that people have difficulty or increase the challenges to get from where the thing you are using to some rival's thing or service. So consumer behavior bias, behavioral economics is a really big deal in this space. Next slide. So one of the things we all see as users of platforms is free stuff. And I put this in quotes because it's a very big misunderstanding. So with Google, it's free search, free email. For Facebook, it's free communications, including photos and videos with your community of friends and family. But it's not really free. So the essence of this is that a consumer trades his or her attention and information in exchange for the free service. Now that exchange fuels some of the most profitable companies in the world. So it is not free in any real sense. It's only free to you because you're trading something that you didn't have to pay for, which is your attention and your information. Next slide. So the information on you is really quite substantial. So this is public. So there was a 2018 Guardian article. So their tech writer basically took advantage of the fact, and you can do this yourself, both Google and Facebook allow you to look at what they have on you. So he did that. And on Google, they had, and he'd been a long time user like many of us, and they had 5.5 gigabytes of data on him. And that's the equivalent of 3 million Word documents. And it included all of his searches, and all of his deleted documents. So this is a remarkable amount of information. Facebook had 600 megabytes of data, which is the equivalent of 400,000 Word documents. All the messages sent or received, all the things that you clicked on and showed an interest in. From this, these companies derive things like your income, your location, where you work, where your home is, and your interests of various kinds. In addition, specific apps in some OSs, so for example, one of these articles talks about Android, which is the Android phones are the alternatives to Apple phones in the current economic environment in mobile communications. They basically follow you around. So they have location information on you that's really quite detailed. And so they can get within literally a few feet of where you might be moment by moment during your day. And from that, you can infer things like where you travel, where you might drop your kids off, all that kind of stuff, which means that they can rifle shot ads to you to focus on the fact if you do a search for nearby coffee, they can give you that information, which is certainly useful. But they can also infer other information from your location throughout your day and throughout all the time that you've been using the device. And some of these articles indicate that you don't have to be using the actual software like Google Search, because these apps will, or particular OSs, basically monitor you irrespective of what you're actually doing with your phone at the time. Next slide. So advertising is really one of the major drivers of these kinds of platforms. So the social platforms, the search platforms, that's different from platforms like Amazon that sell you mostly stuff. But the real value in digital advertising, so the most valuable are search ads. So you type into your search box, whatever you use, best coffee pot or best small SUV, something along that line, that it can be inferred to indicate you have an interest in buying something. So this enables advertisers to target you with an ad for a specific car, or there may be a Williams Sonoma ad that includes, here's our cut on what the best coffee pots are, whatever. But these are the most valuable ads in the system. And they derive their value from the fact that the information you are putting into your search engine is an indication of your interest in buying something. The other kind of ad, these are display and social ads. So these kinds of ads are basically not as rifle shotted as the search ads. So you may have, they know based on your activities online that you have a certain income, that you have a certain location, etc. And that will allow them to present ads that may be somewhat relevant to you, not as cleanly relevant as the search ads, but somewhat relevant. These two kinds of ads are priced in a different way. The search ads are typically priced on a cost per click basis, which is the advertiser will pay a certain price based on your clicking their website. So they present an ad. If you click on that, the search engine gets paid. Digital display and social ads are priced differently. It's a CPM, cost per milli or 1,000 views. So if you don't have to click anything, but the ad appears on something you're looking at, that will be priced in that way. These are significantly less expensive than search ads because they tend not to produce the kinds of, they're called conversions, either a sale or an engagement, which hopefully will, from the advertiser's perspective, result in a sale. Next slide. So I'm going to talk about this a little bit more. There's a very complex, at least in the digital advertising world, a very complex back room. And on the left side here, you see website publishers. So I have space on my website for, food products or something, or I'm a cooking website. So I say I'm presenting on best coffees or some such. Advertisers on the other side, so they are bidding on the ability to present on relevant websites. So these two sides get together at the end of the day. It's in the ad exchange, which is in the middle. In this world, these transactions take place literally in milliseconds. So they are presenting, for example, cooking.com is presenting something on coffees. To put an ad on that is milliseconds later. So you as a user may not notice that there's been anything in the background, but there's been a bidding process and a presentation process that brings an ad to cooking.com's article, which will then include an ad for, again, Williams-Sonoma or whatever. So there's a lot of technology which actually can be manipulated. There are cases about this, which I'll talk about in a few minutes. But it's important to know that there is a significant back room here, which is very complex and very, very fast. So next slide. So sometimes people talk about digital information as the new oil. I'm not sure that's completely accurate, but certainly you will see things like that. So the deal here, though, is that this information, coupled personal information, in particular search information, can get converted into enormously profitable activities. And I'm citing here, an article I found that was pretty useful from the French Competition Authority. Basically, 2016 or so, this is all public, 90% of Google revenue and 95% of Facebook revenue was from digital advertising. So when you read about the profits that these companies are enjoying, it is digital advertising, which provides for this ability to match people's interests with an advertiser and do it over and over and over again. And it is enormously lucrative. Next slide. So one of the things which is sort of an interesting policy question, and there are issues about this which I think have not been fully resolved, so I'm giving you a couple of views on this. So the combination of network effects and scale effects can create barriers to entry. That is, if you were the second or third to get into this business, you might be able to function well, if you're in the oil business or the steel business. But in this business, network effects and scale effects give the first mover enormous advantages. So this is an article which I'll talk about in the resources discussion. But the idea here is, one perspective on this is that the market will tip towards a specific company, towards one or a few companies in that space because of these network and scale effects. So the alternative, so there was an idea that used to exist more in the 1930s through the 50s, that some kinds of businesses were natural monopolies, airlines, things like that. Economists generally don't believe there are real natural monopolies, but Professor Hovenkamp, who now teaches at Pennsylvania, one of the real deans of antitrust law, writes a major treatise, which is widely regarded as one of the best to use if you're a practitioner. He said, look, these are not natural monopolies. It's not enough that they've got these network effects and scale effects. When you actually look at what these platforms do, the way they guarantee their dominance is because they use exclusionary practices, usually exclusionary contracts of various kinds. So when I talk about cases watch for cases in which it is exclusionary contracts that are being addressed as opposed to these network effects and scale effects. But the contracts in those cases are built upon these network effects and scale effects. Next slide. So another aspect of the platforms in the United States, also around the world, is that there has been a lot of growth by acquisition. So the first one up is Google. So they have done 235 acquisitions between 2004 and 2018. They did 36 acquisitions of other companies in 2014. So a lot of their growth is through purchases, which are subject to the Clayton Act, which has a provision on anti-competitive mergers. Now, in the Google world, they acquired two important companies, Android, which had the foundation for what became the Android operating system, which is one of the two dominant mobile operating systems in the United States and around the world. And then DoubleClick, which is a key piece of technology in the ad tech stack. These acquisitions are now being challenged. They weren't challenged at the time, largely because I don't think everyone appreciated how significant these were. Facebook, similarly, lots of acquisitions since the inception of the company. Estimates are that they roughly have spent $26.15 billion on acquisitions. These include the acquisitions of Instagram and WhatsApp. These two apps are now frequently described as, originally potentially very significant competitors of Facebook. Facebook bottom up eliminated them as competitive threats. At least that's what plaintiffs are saying about them. There's some interesting economics around this, this is an article which I think is interesting. Platforms have a strong interest in acquiring firms that will reduce multi-homing. So what's that? Multi-homing is the idea that, well, I'm going to use Google, but maybe I'll go do some stuff at Bing, or I might use Facebook, but I might also want to use WhatsApp and Instagram. A lot of folks were Facebook, Instagram combo people before this acquisition took place, but afterwards, obviously, they were both owned by Facebook. So multi-homing would expand competition. Reduction in multi-homing increases the power of whatever the incumbent is that is able to suppress multi-homing. Next slide. So here are some resources. This is not a required take-home assignment. I just want to surface some things that if you want to do some extra reading, here's some things I think might provide a range of things that would be worth looking at. So the first is the Stigler Committee on Digital Platforms. So there's something called the Stigler Center for the Study of the Economics in the State. So this is associated with the University of Chicago Booth School of Business. Notwithstanding some snarky things I might have said about the Chicago school that has a very conservative perspective on economics, the University of Chicago, through the Stigler Center, is actually doing some really cutting edge work. And this represents that kind of work. This is what a new generation of economists are looking at and talking about in terms of how antitrust should work and how economics works in the real technical world. I like this basically because it's readable, and it also is based on the perspective of some really first-class economists. So you get access to economic views which are interesting and in a readable way. The next one is a summary. So there have been a number of major studies around the world about how platforms work how they should work, how they affect other parts of the market. So this is an interesting report. It's written in a slightly geekier way than the Stigler report, but is sweeping. So this reports on 22 different reports, including reports done by the Competition Authority in the United Kingdom, the EU's commission, the Japanese antitrust authority. So it goes around the world. So this gives you as good an overview of what antitrust people and economists are looking at and thinking about in the context of platforms and how they work and how they are weak and what kinds of things should be done. The third one is absolutely contrary to the first two. So this is the key author here, Joshua Wright. I had the opportunity to work with him when I was at the Federal Trade Commission. He was a commissioner, Republican appointee. This article basically says these cases against Google and by extension, other kinds of platforms, they're bunk, and here's why, which will give you, I think, an alternate view of the same facts, how they can be interpreted, et cetera. And then finally, Herb Hovenkamp, this article is relatively recent, and this is an antitrust lawyer's view, moderate kind of antitrust lawyer. How do we interpret these facts and how do they fit? How do these attributes that we've talked about in terms of platforms, how does that get refracted and addressed through current and potentially evolutionary versions of federal antitrust law? So this is something worth taking a look at as well. Next slide. So selected cases. So I just want to take you through these. And so these are high level summaries of, both sides of the aisle, if you will, in terms of what's being said. So the first one is people of the state of California versus Amazon. This is a case I think I mentioned before. This is pending in San Francisco Superior Court. It's brought by the Attorney General of California on behalf of the public. This is under the Cartwright Act and the Unfair Competition Law. And what they are asserting here is that Amazon, so by way of background, Amazon has what are called most favored nations clauses, MFNs in the trade. So what Amazon tells its retailers, so if you're selling coffee pots on their site, you pay for their processing of your sales and things of that nature. So there are charges associated with the use of the Amazon site. Some retailers argue that these charges are very high, and they would like to go to other retail platforms and sell their coffee pots or whatever cheaper. And so under a most favored nations clause, that is prohibited. So what these say is that if on Amazon, I'm selling my coffee pot for $100, and part of that is a fee that I'm paying Amazon, I can't go to ABC alternative and sell it for less than $100, even though the fees charged by ABC platform are significantly less. So this precludes the ability of retailers to go someplace else and sell more cheaply. And this case is in process. Jump to the next slide. So the defense argued various things which will be of interest to you. One is that the Cartwright Act, which is California's major antitrust law, has no single firm prohibition. There's no prohibition on monopolization under the Cartwright Act. Therefore, you got to look at this through the lens of a combination and restraint of trade. So defendants here said the agreements are unilateral. There's a body of law that says you can announce a policy, and if you don't enforce it or force people to take it, then it's unilateral, so not an agreement. So that means that they argue that the Cartwright Act doesn't apply. They also argued that vertical restraints are judged under the rule of reason, which is a broad balancing test under federal law. California courts should do that as well. They also argue, remember we talked about the unfair competition law, which basically picks up other laws in its unlawful prong. The court, the defendants here, for Amazon, basically said it only includes California law and not the federal Sherman Act. So all of these arguments were rejected, made but rejected. So this is just to be technical briefly. This was a demurrer. This is like a motion to dismiss federal court, but it's an early motion that's made by defendants to say the law doesn't favor you. This isn't the case. We shouldn't go forward. That demurrer was denied. Next slide. And so that case will continue. This case is Epic versus Apple. So Epic makes games. So the concern that Epic had was that Apple was taking basically 30%. So if you bought a game, 30% of that went to Apple. The Epic business model is to sell you stuff, extra powers, things of that nature. So they also do purchases within the app. And Apple insisted that all of those purchases go through them. And so they would get 30%, plus you had to use their financial mechanism. You couldn't go out and go to Citibank or something and get something cheaper. So the trial court went through an analysis and said this wasn't a monopoly because it concluded that it was all digital mobile transactions. So remember we talked about how to expand and contract the relevant market. The court here took a fairly broad relevant market analysis, which she did on her own. Neither side proposed this market, but the market share within that market, that relevant market determined by the trial court, was 52 to 57%. So not enough under current federal antitrust law to represent monopoly power. The court also said that there was insufficient evidence that the things that Apple was doing were anti-competitive. It was successful, but the court here says success is not illegal. And then finally, the court, in an interesting and somewhat surprising move, at least to the parties, as I understand it, was that the Apple, these are anti-steering clauses, or you can think of these, the practices that Apple was using to deny Epic the ability to sell its products cheaper, its services cheaper, were not properly disclosed to consumers, and therefore violated California's unfair competition law. Next slide. So this went up on appeal, and that was argued in November of last year. If you look at this like a number of sort of reports, was reporting that the court was having a hard time addressing what it described as the inconsistencies in the trial court opinion. So this is to be determined, but this is regarded by the Ninth Circuit, which is the intermediate court of appeal, federal court of appeal that serves California. They've made this one of their cases of interest. So this has its own spot on the Ninth Circuit website, so you can go there and get, up to the moment developments in this particular case. So you can see here battles about market power, whether the activities are, improper conduct or not. So we're starting to see some of these themes emerge. Next slide. So essentially the same kind of case was brought by Epic against Google. And it basically, here they define two distinct markets for Android app distribution and Android in-app payment processing, and alleged that Google had anti-competitive contracts which foreclosed companies like Epic, this is a game manufacturer, from using cheaper alternatives and charging less for its services on the Google site. Next slide. So the motion to dismiss. So Google said Google had no duty to deal under controlling Supreme Court and Ninth Circuit cases. This is a Trinco kind of argument. We've mentioned Trinco before. No harm, the defense said, because there were other ways of providing these services, that is, on Epic's own website. And then this last two, no duty under Trinco to allow them to process outside of the Google system, which also is a 30% cut. So that was the motion to dismiss. Next slide. So the plaintiffs responded that unlike Trinco, what they're trying to do is not, it doesn't turn on a duty to deal, but a freedom not to deal with Google. They don't want to have to deal with, be required to go through the Google system. They also said that the contracts foreclosed alternate paths of distribution. Google prevented all but the most tech-savvy users to independently get apps or use alternate payment systems. Herein of some behavioral economics, it's just hard. There's lots of friction points to go to alternatives. So this is an example of that. And then this is an example of common law lawyers on the plaintiff side trying to distinguish, in this case successfully, the Trinco requirements about the duty to deal. So they say Trinco only applies when there's a unilateral refusal to deal at all, as opposed to having an obligation to deal reasonably or more appropriately with conditions that a monopolist may want to impose on purchasers or users. Next slide. So Epic was allowed to amend its complaint. So this is going to trial. The trial court concluded, so this is maybe inside baseball in terms of litigation, but this appears in another case I'm going to talk about. So one of the problems that Google has is that they allowed their top executives to decide whether or not to preserve chat messages. So plaintiffs here basically said that is a form of spoliation, that is, they illegally destroyed documents, these chats, and that they would have been relevant, they would have helped their side of the case. So the court has decided that, in fact, Google acted improperly. The specific remedy is up in the air. Trial is now set in this case for November of 2023. So the end of the year, this will go to trial in the Northern District of California here in San Francisco. And so we'll see how this all turns out. Next slide. So Federal Trade Commission versus Facebook. So the commission asserted that Facebook had a monopoly share in something called the personal social networking services market. And then, so that was the monopoly power assertion that they made. And then secondly, the second element, they said the bad conduct, if you will, was really two things. One was they improperly acquired two potential competitors, Instagram and WhatsApp. And then they also prevented interoperability between Facebook and other apps. Next slide. So the court, looking at Facebook's motion to dismiss, this is the same as the demur and state practices in federal court. So this was a pretty clean win, except for the last bit, for Facebook. The court agreed that the FTC had not properly pled monopoly power, failed to plead conduct that was within the bad conduct prong of Section 2. It did better, the court said, with its challenge to the two mergers, but still it was not enough. But, this is a big but, FTC was allowed to amend its complaint. So recall that these motions to dismiss / demurs take place at the very beginning of a lawsuit. Frequently, plaintiffs are given the opportunity to replead and kind of fix it. The one thing to note here is there were a number of states on this one. One of the things that the trial court said, this is in the District of Columbia, DC District Court, was that they also, as states, challenged the two mergers. And the court there said states are not in the same status and cannot do the same things the federal government, like the FTC, can do. So a defense called latches, that is, they should have challenged these mergers long ago. They can't do it. That is now on appeal to the DC Circuit, and that's still pending. Next slide. Next slide, Brian. So, go back one. So the Federal Trade Commission repled, and they actually did quite well. So the court there said, yep, marketing, personal social networking services is a proper market. Within that market, there was an 80% share. There were barriers to entry, so that this gave, at least they properly claimed, the existence of monopoly power. The court went on to say the two mergers, those allegations were sufficient to support monopoly maintenance claims. On the other claims, the court said, look, Facebook stopped doing that years ago under a particular section of the FTC Act. It didn't appear that they were sufficiently live to make sense. Therefore, this case is now focused on these two allegedly problematic mergers. No agreed trial date yet. FTC proposed a December 2023, again, at close of this year date. Facebook says it needs more time, but this should be in front of a trial court relatively soon. Next slide. So United States versus Google, this is a search case. Try and go through these a little quicker. So the basic deal here is that the allegation by the United States and 14 states, including California, we're very happy to have them in this case, is that Google uses exclusionary contracts with original equipment manufacturers, Samsung, Apple, others, and wireless carriers to basically require them to give Google the default position on searches. You can change away as a consumer, but the default will be Google. And the plaintiff's argument is that these contracts deny the ability of rivals to efficiently access the markets. One aspect of this case is that these contracts involve Google paying OEMs and wireless carriers significant amounts of money. We're talking billions of dollars a year to support these contracts. Okay, so next slide. So the Google's motion for summary judgment, the contracts, they say, are actually competition on the merits. Others could enter into these contracts, and we're just better at this than anybody else. They say United States versus Microsoft, which is the key case in the DC circuit where this case is being brought, does not condemn these kinds of contracts, they say. And they further say that the challenged agreements do not foreclose a substantial share of the relevant markets. So that's their motion for summary judgment. Summary judgment is after discovery before trial. It's a motion to end the case with the court being able to look at least some facts. Next slide. So the response of the United States and 14 states is that Google's dominance confers significant scale economies. Defaults are the most powerful and efficient means of distributing search engines. These kinds of contracts do not represent competition on the merits. They need to be analyzed, so this needs to go to trial. And a point that seemed to be well taken by the court, but I'm sure my colleagues on the other side will disagree with this. The fact that Google pays billions every year for default exclusivity on major channels of distributions is a big deal. And the ultimate conclusion from the perspective of plaintiffs in this case is that Google's exclusionary contracts lock rivals out of the key distribution channels of distribution. Next slide. So the oral argument on this case, this summary judgment motion, argued last Thursday. So this is right up to the minute in terms of what's going on here. So the court has not made a decision here. So you can read the various articles about people's perspectives on who won or not, and how what they might have won or lost. In addition to, this is similar to what you saw in the Epic case. The plaintiffs in this case also have made a motion asking for sanctions against Google because it destroyed chats. And the court has this under active consideration. That has not been argued, but it's under active consideration. So the briefing appears to be largely complete, although Google recently asked for an opportunity to do what's called a surrebuttal, and the court's deciding whether that's going to be possible. That's an extra, rarely granted opportunity to brief something. Trial on this one is set for September 12th. So in mid-September of this year, trial on the merits, that is whether Google violated the antitrust laws, that will start, expected to be a 6-8 week event in the District of Columbia trial, in a District of Columbia District Court trial court. The case has been bifurcated. So once the merits are decided, did they act improperly, there'll be a separate trial on appropriate remedies. Next slide. So another case also brought by the United States, this now with 17 states, including California. Again, we're very excited to have them. This was filed in the Eastern District of Virginia. This is right across the Potomac from Washington, D.C. in Alexandria. This is known as the Rocket Docket District Court, and a jury trial was demanded. Plaintiffs have alleged 3 markets in the ad tech stack: publisher ad services, ad exchanges, and advertiser ad networks, monopoly maintenance, and attempted monopolization. And the relief requested is injunctive relief, stop doing these bad things. And interestingly, this is a Section 2 theory as opposed to a Section 7 theory, divestiture at a minimum of specific acquisitions that were previously approved. the United States is pleading, has pled a damages claim. Various United States entities, U.S. Army is the obvious example, advertise a lot. They are actually purchasers of advertising online in the digital space. One implication of this damage claim is that plaintiffs will get a jury trial. So most of these things are done before a single judge. The jury is a very different, you can argue a case very differently in front of a jury. So this will be an interesting situation, because these kinds of cases, the advertising stack in terms of how it works, just a hideously complicated thing. But those were the allegations. Next slide. So this is an example of this ad tech stack. On the buy side, on the advertiser side, you can see up at the top under the blue top piece of text, plus or minus 80% market share in Google Ads. So that's one of the things that the government is focused on. On the other side, the publisher DoubleClick, which was one of the acquisitions, that is one of the pipes through which websites send their opportunities for advertising to the ad exchange. Google has a 90% share. Next slide. And there are additional contractual limitations in terms of using these things. Perhaps just to pick out a few, there was a thing called header bidding, which allowed advertisers to skip or jump over the Google process. It's called header bidding. And there were some companies that specialized in this. They took various steps to suppress that so people couldn't go around Google. They also suppressed multi-homing. Remember, we talked about multi-homing being a way to use a different way to get to the market. They suppressed multi-homing threat by purchasing AdMeld, which is another one of the mergers that is being challenged here, and did various other things. These are a set of basically contractual limitations, which protect Google's monopoly, so plaintiffs say, in a very significant way. Next slide. So the status here is there was an effort by Google to shift this case to New York, where there'd been a pending case brought by various states led by Texas. And Google, no surprise, wanted to get this case moved from Virginia to New York. That was opposed by the United States and its co-plaintiff states. That was denied by the trial court judge. Google filed a motion to dismiss. Primarily, they argued no monopoly power, no actionable monopolization conduct that was improper. DOJ and the states countered that plausible relevant markets, meritorious claims for monopolization and tying, and that the United States was a direct purchaser of digital advertising, thinking again about the U.S. Army and similar, so they get a jury trial. That is in play. There's been no decision as yet, but you can see the same kinds of, this is not actionable bad conduct. There isn't enough market share to make this meet the monopoly power prong. Next. So this raises, I think, some things for you guys to think about in terms of what you want to do. And I'm not going to advocate for any of these, but just to surface, the idea here is to surface for you what may be some of the things that your committees of experts might want you to think about. And my hope here is to provide a context, a broader structure within which to think about those things. So the first thing is, do you want to adopt some version? If you're going to do monopolization, yes, no, you need to decide whether you want to do that. If you do you want to adopt the federal power plus conduct combo? Recall from last time that there are two basic elements. Assuming you want to do that, what might that look like? You can stick with the current federal 60-65% of a relevant market, or you could reduce it. So if you were to follow the EU approach, that is a much smaller market share. You can see that market share, market power, monopoly power has been a constant theme in all of these cases. So you could address that by changing that percentage. You could clarify that direct evidence of monopoly power is sufficient. In monopolization cases, there is oftentimes very substantial and direct evidence of monopoly power. The argument by plaintiffs oftentimes is that if you've got that evidence, you don't need to go through the process of defining relevant markets. It's just, if you've got direct evidence, why would you use indirect evidence? But that's a kind of litigation issue which may turn out to be important. Now, turning to the conduct element, you got a couple of options here. You could use the common law that currently exists in the federal system. And it's pretty rich, but you could also follow S225. This is Senator Klobuchar's bill in the United States Senate. They actually define what exclusionary conduct means. So here is some of the text. So your policy question will be, if you're going to do the two-element approach that's currently exists in federal law, with respect to that second element, do you want to define what that means? Or do you want to rely in some fashion on federal common law? The other thing that we also see in some of these pieces of legislation is shifting of the burden of proof to the defendant for either specific kinds of conduct. If it's exclusive dealing, then the burden shifts. This is a EU approach to these things. Or defendant has a particularly large share of the market, then certain kinds of activities become, you would argue, or you would draft a law so that the burden would shift to the defendant to show that this was good for the public. So there are lots of options here, even within the assumption that you might follow the current federal power conduct structure. So these are the kinds of issues that you might look for in the kinds of reports you're getting from your committees, and do some thinking about it. Next slide. Treatment of behavioral economics. In this space, how consumers actually act, with respect to, say, defaults and things of that nature, the battles frequently in the trial courts are between, the theory of microeconomics that consumers act in a certain way versus the current understanding of how they actually act. You might want to consider putting your finger on the scales in terms of saying this information, how people actually act, is the preferred form of information that should inform California trial courts, or you could just leave this open to the common law process. And there should be, within the next 12 months, some perspectives on that from these various cases that are now pending and about to go to trial. Next slide. So duty to deal, you saw in various of these cases the notion that this Trinco case, the duty to deal basically says they don't have to do anything that helps anyone else in the ecosystem that they've created. And that's a very powerful and a frequently used argument by defendants. It is also the case that plaintiffs are pushing back on that and saying, no, actually that Trinco thing only applies to very specific and very narrow circumstances. Here's an example of that being used. So, again, we're going to get some more information on this. This is fairly raised in the Epic v. Google case. So and also fairly raised in the people of the state of California versus Amazon case. So this you should watch for this. But what do we want to? What would you want to say, if anything, about the duty to deal? You could also state that Trinco is not the law of California. That's how S225 approaches it. In the alternative, you could do something like revive clearly the essential facilities doctrine and say, under certain circumstances, you as a monopolist need to work with people in the environment around you. I'll get to this in a moment, but there's this really interesting statute, if you will, in the European Union called the Digital Markets Act. And that sets up, defines a group of platforms called gatekeepers. So if you are a gatekeeper, think about Amazon, then you will be obligated to provide certain kinds of equality to your rivals or other sellers that use your platform. So codifying the essential facilities doctrine could look like this, or it could be some version of this gatekeeper approach that you see in the Digital Markets Act. Next up. Non-discrimination. So, the argument is frequently made that companies like Amazon, Google, others prefer their own offerings versus those of rivals or others. So, apply the current federal duty to deal case law. Equal treatment is, I think, a push under any circumstances under the current federal law, but you could just adopt federal law. You could provide that large platforms will be limited to certain lines of commerce to deny them the interest in imposing different rules for rivals. That's expressed in this HR 3825. There's language to that effect in that legislation. Or you could preclude self-preferencing by platforms of a specific size or scope. That's in this S2992. Here is below that, the subheading here. This is a cite to the EU's explanation of the Digital Markets Act. And this has that gatekeeping idea that if you are a platform of a certain size, you will owe certain kinds of duties to others. So that non-discrimination, equal treatment, that's going to be an area that certainly the public and retailers will be raising with you. So these are some of the choices that you might be able to make. Next one. Mergers. Again, recall that a lot of growth by these platforms is through acquisitions. So you could stand pat and say we're going to rely on federal anti-merger provisions that come through California law by way of the unfair competition law. That's one place to land. If you want to consider a state level merger provision, some of the things that are going on in Congress may inform what you want to do. So the current Clayton Act, it's Clayton Section 7, that prohibits mergers. And that prohibition is on mergers that substantially lessen competition. And there's case law around what that means. S225, again, this is the Klobuchar sort of omnibus bill. That bill suggests that the standard should be adjusted, the statutory standard should be adjusted to say mergers can be challenged if they create an appreciable risk of materially lessening competition. It's worth taking a look at that, the description of why that's important in this legislation, but that would be a significant adjustment in what at least state level prosecutors would need to show in order to challenge a merger. You could prohibit mergers of a certain size or effect. This S3847, they have this legislation has prohibitions that say things like, if a company is over X billions of dollars in size, it can't acquire anybody else. Or if they are a tech platform and they are of Y size, they can't acquire. That would be one approach, just a prohibitory approach. The other approach is burden shifting. So some version of platforms of a certain size will be prohibited from engaging in mergers unless they demonstrate in various ways that the acquisition is pro-competitive. And an example of that is in this HR 3826. So there's a yeastiness, there's a lot of action sort of at least being proposed in the Congress. None of these bills have passed yet, but there's a lot of support for them seemingly. And there's no requirement that you do any of these, but these are the kinds of broad brush sorts of options you may have. Since again, you are almost unique in starting over with a clean piece of paper. And what does a 21st century antitrust law look like? Next slide. So some resources. So I really like this first one. So this was designed for non-technical members of Congress. So there's a thing called the Congressional Research Service. I think there's something similar to this in the state legislature as well, but the name of it escapes me. So this is a roughly 85, 90 page compendium on an overview of federal antitrust law and issues associated with platforms, and it summarizes the pending legislation and what the rationales of the proponents are and what the contrary views are of the platforms and those that oppose these pieces of legislation. So this is a nice thing to read. The next piece is testimony given by Fiona Scott Morton, who's an economist at Yale. She's written extensively on antitrust and its current problems vis-a-vis more modern antitrust economics. But she goes through the existing and pending federal antitrust proposals and suggests from a pure economics perspective why she thinks it's important that various parts of them pass. This is clearly written. It's about 12, 15 pages in length. She notes, gives you a crosswalk at the end to the Digital Markets Act. So you get a sense of how the US Congress and the EU law may be cross-fertilizing in interesting ways. Finally, Rich Gilbert, he's an economist who was the chief economist at the Antitrust Division several years ago. He's currently was at Cal, I think now teaches at Stanford. He basically does this is an article which will appear in the Annual Review of Economics in August 2023, but the draft is available at this URL. He takes a fairly traditional kind of reformist perspective on some of the pieces of legislation that are being proposed. So an interesting read and provides some leavening to the other resources that I've described to you here. Next up. So thanks. It really has been a treat for me to have the opportunity to speak to you about these issues. And I'm certainly open to questions. And I hope I didn't go too fast because this arc, we arced across a lot of territory this one.
I see the ambassador and the viceroy. And Victor.
Thank you. Thank you, Chair. Professor Green, thank you very much for the superb set of briefings. It's quite
thank you.
extraordinary, the amount of time you put in and the fact that you've made so many of the issues at least marginally understandable.
That's high praise. Thank you. Yeah.
At the outset, I have two questions, if I might. One is, and I note that you have mentioned the EU law a few times. Is there a best practice, in your view, statutory framework involving regulation of networks out there, whether it's the EU or something else? And I ask because in some ways, US regulation tends to be slower than elsewhere because our campaign finance laws are so leaky, which allows, in my view, immense distortion as a result of large flows of money that can't be traced. That same dynamic is not present outside of the US in other developed environments. So is there a digital regulatory framework outside the US that you think is particularly worth us studying as we start with our blank sheet?
Yeah, I think 2 or 3 places to look. I think the Digital Markets Act is really an interesting piece of work. I mean, it was designed, so in the world of antitrust, there's sort of general antitrust, and then there are what are called sectoral regulatory structures. So the Interstate Commerce Commission, or the Federal Communications Commission, for example, that's a sectoral regulator. So the DMA basically creates a sectoral regulator for platforms, fundamentally. There is a, you might also look at the Competition and Markets Authority, CMA, in the United Kingdom. They also have some interesting things that they're about to do. There has been legislation. They're about to put, I don't know, 100 people to work on this specific area with more to come. That legislation will also be worth looking at. And that was passed by, England is always interesting because there are Tories there. They're dominant, but they still passed this really interesting statute. That will be emerging in terms of its specifics, but that's worth taking a look at. And then under the broader general EU antitrust law, they have taken on people like Google and Amazon. That has already occurred starting years ago because their statute is different. These ideas of burden shifting and things of that nature. I would look at all of those various places. My understanding from Brian is you're going to have a terrific speaker on EU statutes and how they work. So I asked precisely that question of that person and see what you come up with. But those would be the places I would look initially.
Great, thank you. My second and final question, Professor. Are there existing cases that deal with a couple of distortions that you mentioned? One, which might be considered fraudulent behavior by networks, which is they track you even if you disable tracking, and they preserve your search history even if you have attempted to erase it. That's one example. Mm-hmm. The other would be the friction issue you mentioned, where it is made extremely difficult to even determine where to go to make your privacy selections. And then when you find it, it's burdensome to work through it and figure out how to do it. have any of those bundles of impediments arisen in the context of evaluating monopoly power? Are those viewed legally as tools of monopoly?
I think the most truthful answer is TBD. So in direct answer to your question, there are cases that deal with privacy, but they focus primarily on whether there was adequate notice to consumers. So for example, there's a case in the Northern District that was just certified, I think, in the last year, in which the allegation is that Google uses something called incognito mode, which most consumers think gives them total privacy, but it doesn't. That was not properly disclosed to consumers. Therefore, there was a violation of their privacy rights. that will be going to trial fairly soon. They've cleared basically all of the pretrial hurdles, as I understand it. So that would be the kind of case you might look at. So for the privacy stuff, the privacy regime in California Consumer Privacy Act, you might want to do some thinking about how they interplay with each other, if that's an area of interest. In terms of friction, one of the claims that Epic makes is that, and one of Google's defenses to Epic is that you can go someplace else and get the Epic games and do these transactions to buy the extra powers that you want to play the game, more fun sort of way. They claim, I don't know myself, they claim that that's a 10-step process. It's so horrific, even the most technically competent people can't do it. So it's a pure friction story, basically. That's part of the litigation that's likely to go to trial later this year. Privacy,
But in neither the fraudulent activity or the friction, you haven't seen cases yet that identifies those as indicia of monopoly.
Actually, in the US versus Google case, in the search case, one of the arguments is that the effect of these exclusionary contracts is that it forecloses people like DuckDuckGo is a company that offers a significantly more private way of searching than anybody else offers. That these exclusionary contracts have basically suppressed their ability to flower in the marketplace. So there's that kind of stuff. The counter, again, from Google, is that competition is just a click away. And, it is the case that many people disbelieve that it's one click away, and whether it's 5 steps or 25 steps. People will argue about that. We'll be in trial on that one in the fall. But, those kinds of things come up in that kind of context.
Thank you.
You're welcome.
I think it was Rick and then Victor.
Okay. I just had two issues as well. I was wondering, does the Interstate Commerce Clause place any limitations on what we as a state can do in terms of regulating these kinds of activities on platforms versus what the federal government might be able to do?
I think it obviously depends a lot on what you do. I mean, that's a key question for you to ask your advisors who are going to be, proposing things. So there are two buckets of focus, or there are two foci, if you will. One is something called the Dormant Commerce Clause. Are you affecting and injuring interstate commerce with this thing that you're regulating? Does it unfairly discriminate against other companies that are located in other places other than California? One of the most interesting aspects of that question is that the largest and most important platforms in the world are in California. So that will affect the scope of this. The other one is preemption based on the current federal antitrust laws. So the most powerful source of preemption is a preemption clause in the statute, which would be some version of, this notwithstanding, these are the standards notwithstanding any contrary state law. There would be something like that. To my knowledge, there's nothing like that in federal antitrust law. So it would be whether or not your proposals, whatever they might be, obstruct the interests that are being protected by federal antitrust law. I think you probably have the better of that based on some of the cases, but those will be the two places you need to ask questions about.
The other thing is, as you were talking and describing some of the situations, the thing that struck me a couple of times was this felt kind of like, should we think of this like a regulated public utility, like, electricity and water and natural gas? Is this the kind of thing that might be in the environment to the way to think about these platforms, sort of a 21st century version of almost a utility?
Yeah, I mean, that's a great question. Microsoft, for example, has advocated to the Congress, I'm sure this is public, that there should be some regulatory structure that deals with privacy and these kinds of platform issues. So, I'm an antitrust lawyer. I deal with, divestitures, prohibitions. You can't do this, you can do that. As part of a litigated process. That's one way to do it. The other would be some version of a Federal Communications Commission that might deal with platforms. I mean, they are different.
California Public Utilities Commission, right?
Yeah, it's different tools. I mean, they have their pluses and minuses, and people have their favorites. As an antitrust lawyer, I should probably tell you my side of this is the better one, but it is. The tools are designed to get to very similar kinds of pro-consumer results through different processes. So the other thing to be aware of is that the Federal Trade Commission, just to sort of footnote this, the Federal Trade Commission has the power to issue regulations. So they have just started to say, I mentioned this last time. They are proposing to issue a trade regulation rule under their FTC Act against non-compete clauses. You could empower, arguably, California Attorney General or the sectoral regulator that you want to create, that they might create regulations in this space. So that would be another thing might be another tool in the toolkit.
Okay, thank you.
It was Victor and then Sochi.
Oh yeah, thank you, Mr. Green, for your presentation. You fill me with anxiety and dread every time you say where rarely do we have an opportunity to completely change all of antitrust law, tabula rasa. And so I wonder how true is that statement, though, in that the New York legislature had a huge set of reforms that got stalled in their legislative branch, and they couldn't pass it out. And Jerry Nadler on Judiciary in the Congress had an effort, which I assume is now dead or stalled because he's no longer the chair of Judiciary, thanks to the House flipping over to the other party. So those are two sets of people, I believe, who were tasked with similar missions as we are, reforming antitrust with sort of an emphasis on how it interfaces with the new tech economy. And so what I'd be curious, for all those questions you posed for what we could do or what we could think about, I'd be very curious. I'm not asking you to do it, but I would like somebody to do it, I suppose, to tell me, how did the state legislature and the US Congress approach each of those opportunities for change and what were, the pratfalls or opportunities there. For context, only a handful of the commissioners here were here during our 5 years of working on mediation confidentiality. And we passed a really long, extensive set of reforms, and no one sponsored them in the legislature. No one was willing to even sign a bill, to put their name on a bill to even propose them. So I'm an incredibly practical person. I really don't want to see the commission work on something that will not pass or have any chance of passing. And I don't want to be negative. I don't think we should hold back on being bold and progressive, but I want to be practical too. And seeing how New York stalled and how the US Congress stalled would help inform my enthusiasm for the areas you've identified that we should look at, as well as my approaches for those areas.
Yeah, that really may be the ultimate question, I think. So a couple of thoughts here. One is, when you look at the Congress, the thing that I find just intriguing as an observer is how bipartisan those bills lined up to be. There are Republican, like the Klobuchar bill. She's also got she's a Democrat, a set of leading Republicans on that bill as well. So it seems to me there, in all of that, there should be a bill or bills that could emerge. That said, no question about it. You're dealing with very powerful interests. If their interests are injured in some significant way, they have the resources to push back. I think it's been a long time since I used to work in the Congress, and then I worked for the state legislature for a while. I think just interacting with the legislators, just to sort of what works, where the votes appear to be. This legislature is, not as tightly balanced as the Congress of the United States is. So you just got a very different political dynamic. But I think, staying in touch with them, there may be pieces of this that you want to spin off as separate bills, whatever. I think you just need to think it through. But I think it's also the case that antitrust is at a point of intellectual inflection. There's a lot of thinking that is just below the surface of federal case law, and where that ultimately goes, don't know. But I think my own sense is this whole area of the law is going to shift, even as a common law process over the next 10, 15 years. But
I'd love to see at some point if staff or somebody else could furnish us a summary of what New York tried to do and what Congress tried to do vis-a-vis those questions you posed to us as being the most important questions. So we just see, how other people tried to tackle it. And not that will, be the rule that we won't tackle something that New York failed to do, but it would inform our priorities.
Well, I having somebody talk to you about that, I mean, I would go to the horse's mouth, frankly, conceptually. I mean, the New York bill was written by the chair of, I think, the equivalent of their judiciary or commerce committees. I would visit with him, so Chairman Cicilline he just is in the process of leaving the Congress to go to, he's the chair of, I think he's from Rhode Island, whatever it was. It was the largest charity in that state. And, you might visit with somebody like that, or a senior staffer that helped count the votes. But I would listen to them and take their counsel. But it strikes me that there is, I think you do have, in my heart of hearts, I think you have opportunities here. I mean, you may not be able to get all or most of this, but I think you do have opportunities to bring to the world some additional perspective of what American antitrust and competition law might look like.
Commissioner Carrion.
Thank you as always. Love your presentations, always a lot
thank
of
you.
great information. My question is, as you've indicated in your last comment, that there's a lot of theoretical influx in the state of antitrust law.
Yeah.
You indicated that there are economic behavioralists that it seems like a significant amount of data of what is the impact on consumers and how consumers are using these platforms. Would you recommend that we reach out to these behavioral economists to present a little bit more and flesh out that data and what that means for the purpose of the changes and potential changes, future changes of antitrust law for the commission to hear?
Oh, that's an interesting idea. Let me do some, this is up to you guys. And I could certainly suggest a couple of names to Brian. Let me think about that a bit. Because the theory world versus real world, there is a big gap. And, it's worth talking to those kinds of people, I think. Let me see if I can get you a couple of names.
That would be great, Professor.
Thank you so much.
Other comments or thoughts from my colleagues for Professor Green? Going once, going twice, seeing none. Professor, always a pleasure. You're so erudite and educated in this area, and you've really been very generous with your time and educating us on this topic in which I think none of us can claim the kind of expertise that you have. So it's a great service that you've done to us and to California, and you have our thanks.
Thank you. Thanks for the opportunity. And again, best of luck. This is such an interesting opportunity you have. So thanks.
I'm sure we'll call you again.
And hopefully you'll join us in coming to these meetings and hearing our information and continuing to contribute as a member of the public.
Oh, well, thank you very much. I'm actually looking forward. I think Brian has lined up one of the best people you could possibly get on the EU process. I definitely want to sit in on that one. And I think your next speaker is somebody who teaches with me at UC Law, San Francisco, who is just terrific on mergers. So you've got some good people coming.
Super. Thank you, Professor.
Thank you.
Ryan, we have DTSC left.
Yeah, and the legislative program memo. The legislative program memo is 2319. It just provides you with an update. Bills are all going great. They've cleared every hurdle so far. No concerns, no action required. And then, yes, the next one would be DTSC.
That must be Steve.
Okay. Hello, everyone. I have a cold. I apologize for my voice quality, worse than usual, I guess. But my presentation will be very short, so hopefully it won't be a problem. As the commission knows, in this study, we are proposing recodification of 2 extensive chapters of the existing health and safety code. The commission finished recodification of the first of those chapters in early 2021, and a bill implementing that recodification was enacted last year. Also in early 2021, the initial part of a recodification of the second chapter was provisionally approved by the commission, but work on that chapter stopped at that time until this year. And so because in 2021 and 2022, there were legislative amendments to the code sections that were provisionally approved for recodification in the second chapter. This memo presents the staff's proposed revision of what the commission provisionally approved back in 2021, incorporating those legislative amendments into those sections. That's all it does. Once the revisions are approved, then they will be incorporated in a working cumulative draft that the staff will begin presenting starting at the next meeting of the proposed recodification of the second chapter, along with proposed additional recodification of new sections in the second chapter. The memo is presented as a consent item. seeking a vote to provisionally approve all the proposed revisions in the memo without discussion unless a commissioner or a member of the public requests otherwise. So is there any request to,
Unless there are any thoughts or comments, we would entertain a motion.
So moved.
So moved by Rick. Is there a second?
Second,
It's been seconded. Discussion on the motion. Seeing none, let's call the roll.
Commissioner Carrillo,
Aye.
Commissioner Carrion,
aye.
Commissioner Kubas,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Simpson.
Aye.
Unanimous.
Thank you, Steve.
Thank you very much. Appreciate it.
Does that complete our agenda?
Does.
Anything
Just
further?
one,
Yep.
Chair, just one thing, which is Professor Green did not spontaneously manifest, so I would like to commend Brian and the rest of the staff for identifying him. He's been extremely helpful. You did a superb job with your selection. Thank you.
Yeah, more like that.
I've been frankly astonished by how willing really high caliber experts are to help us if we simply ask them to.
That's fantastic.
It's a great public service that they're doing.
An excellent point, Ambassador. Jane?
Is it appropriate, Brian, for a chair to send a letter thanking him on behalf of the commission for his help?
Yeah,
Happy to do that.
I would think so,
That would be
absolutely.
Really nice.
I can do it on my center stationery unless there's a reason not to. Okay. Other closing thoughts or comments from the group? Going once, going twice. Seeing none, thank you, everyone. We stand adjourned.
Thank you.
Thank
See
you.
today.